Good day, I'm Nathaniel Chris Silva from 4G1 Bachelor of Science in Criminology. Um, this is my midterm video examination in criminal procedure, Rule 114 to Rule 118. First is Rule 114. Rule 114, which is bail, anti-rule 118, which is pre-trial. So Rule 114 bail, bail is a matter of rights granted to a person for the release in custody of law, and um, of course this can only work if a person convict is not punishable by death, reclusion perpetua, or life imprisonment. I have learned that if a person is granted of play, the court may restrict him from traveling or limiting his travel, and if a person is being released on bail, the court may forbid him to travel outside the country, or he cannot leave the country. So bail actually has four categorization: the property bond, corporate security, cash bail bond, and recognizance. So let us start with the we say property bond. This is where a person cannot grant his bail through giving a cash money. So it can be done by giving his property, which is equivalent to the amount of bail. Next is corporate security. This is where a person is being engaged with a business. So if a person cannot bail himself, then his corporate will provide one for him. Next, cash bail bond, from the word itself, cash, meaning it is a common way in granting bail by cash money. And lastly, the recognizance. So if a person cannot grant himself because of a poverty, then the court will give a condition which is favorable to the court, and he accused himself. So there is also another reason for granting a bail. First is if a person has a serious sickness and other humanitarian reasons. So there is a circumstances that can actually cancel the bail. First is the surrender of the accused. If the accused already confess that he committed the crime, so there is no need to bail. Secondly is the proof of death. Of course, there is no need for bail if the accused is already dead. And lastly, the dismissal of the case. If the accused prove is innocent, there is no need for bail. Let's proceed to Rule 116, arraignment. Arraignment define the proceeding in a criminal whose object is to fix the identity of the accused, to inform him of the charge against him, and to give him an opportunity to plead. On my own understanding, arraignment is to inform the defendant of the criminal charges against him or her. We're able to be ready and aware him herself in court, like what I've said earlier. Arraignment is the first in the criminal proceeding up to promulgation of judgment. And the validation of arraignment, the accused must be arraigned within 30 days from time court acquires jurisdiction. Before the court where the complaint or information was filed or assigned for trial, and the judge or clerk, by furnishing the accused with a copy of the complaint or information, the language or dialect he or she know. Improvement, plea of guilty. A plea of guilty is improvident if it was made without proper advice or recklessly entered by the accused without comprehending its seriousness and consequences. Because of emotion, nakapag akso from that, you can withdraw of improvident plea of guilty at any time before the judgment of conviction. becomes final. The court may permit an improvident plea of guilty to be withdrawn and be substituted by a plea of not guilty. Next is Rule 117, motion to squash. Define a motion to squash is substantially the equivalent of a motion to dismiss in civil cases provided in Rule 116, Section 1. It is a formal motion filed by the accused before the arraignment. You can file the motion to squash at any time before entering his plea. The court only won't grant the motion to squash. Also, the court may order that another complaint or information be filed. However, there is an exemption with the ground is extinction of criminal liability or double jeopardy. Double jeopardy define the rule of double jeopardy means that when a person is charged with an offense and the case is terminated either by the acquittal or conviction or any in manner without the consent of the accused, the latter cannot again be charged with the same or identical offense. It's embodied in the maximum bis in idem, which translates literally from Latin not twice in the same, meaning no person shall be punished in the same offense or twice. Let's determine the difference between acquittal and dismissal. Um, yung acquittal, it takes place when there has been a full-blown trial based on merits and he is not found guilty for whatever reasons. While the dismissal naman takes place when there has no full-blown trial and the case was not decided on the merits. The last topic that I discussed was the Rule 118, pre-trial. Pre-trial is mandatory or recognizable by the Sandigan Dambayan, Regional Trial Court, RTC, Metropolitan Trial Court, MATTC, Municipal Trial Court in cities, MTC, Municipal Trial Court, and Municipal Circuit Trial Court, MCTC. The court shall, after arraignment within 30 days from the date that court acquires jurisdiction over the person of the accused, order a pre-trial conference, pre-trial agreement, all agreements or admission made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel. Otherwise, they cannot be used against the accused. Pre-trial order. After the pre-trial conference, the court shall issue an order reciting the action taken, the facts stipulated, and evidence marked. And that's all.